Lord, sir, Lord, I am a higher secondary school teacher working without salary, Lord, for last 20 years, Lord. I am working without salary. One last time, your Lordship permitted me to file an application.
July last week.
Lord, I filed the application for salary, Lord.
802. 802. Yes.
May please, my lord, the date is showing on 27th. My lord, I'm paying for not to be deleted.
My lords, the
804. It is not in the list. 804. 804, please. Let it be in August. July or August.
Lords, this is the matter which has a reserved judgment. We had filed an affidavit that is not come on the record because of the judgment reserve. So, my lords, we just we've handed over the copies other day on the matter. And even the written sub. Even the written submissions have been filed. Oblige, my lords.
Lord, I'm requesting for a passover. I'm led by Mr. Siddharth Devi. He's on his legs. Grateful, man.
Yes, please, my lord. Yes.
My lord, we have served the complainant, my lord. Since it was a complaint case, your lordships had asked the state to serve the complainant, my lord. The service is complete, my lord.
Where is that service report? Office report doesn't indicate so.
No, my lord, affidavit of service has been filed, my lord. The office report indicates that affidavit of service has been filed. My lord, one opportunity may be given, my lord, the complaint.
I'm behind the watch for more than 2.5 years. This I'm saying, my lord. And this is, FIR has been registered after a delay of 3 months. And there is an allegation on the basis of information received from one Jagat, my lord. I can show. It's all right, otherwise party order.
My lord, the complainant has been served. He has to be heard otherwise.
What we can do, they are not.
No, that's correct.
You see the situation in this
My
case.
lord, that's correct, my lord.
Have you seen the?
Summons were issued, my lord. He did not appear and thereafter MBW was issued, my lord.
Why we have keep inside 21 directly comes in the pay. Only the
My lord, I'll leave it to you, lordship.
entire case is based on it. 201 is there.
That's correct.
Substantial evidence
That's
case is
correct.
there. 2 years, more than 2 years is in custody. That what he was found lying on somebody has said, oh, all these persons have did it.
That's correct. My lord, I'll leave it to you, lordship.
We are keeping in Passover. Let us see if somebody comes there, it's all right, then I see pass.
That's correct.
Lords requesting for a short Passover.
Item 5.
Who filed this letter, sir?
State of Kerala.
Huh?
State of Kerala filed.
Why, sir?
The entire case is created just to avoid the payment, my lord.
Just please. Why this letter, sir? For behalf of the student in a bail petition.
Lordship, we are seeking some time to file counter, Lordship.
So who denied you to file the counter, sir? We have not denied you to file the counter.
Lordship, I'm only requesting a week time, Lordship.
Like a week's time. This is during vacation.
Okay.
A week's time is free.
Let me keep it for Friday, man.
The counter is allowed. Less during vacation.
Item 8.
Not being the regular bail matter. Just during vacation. Yes.
I appear for the petitioner through VC. Milord, may I please highlight, Milord, few important facts. The offences charged are under section 420 and 409 IPC. I have been in custody, Milord, for more than 4 years and 7 months. Milord, may kindly see the impugned order at page number 4, please, Milord.
I filed a counter last night.
Please tell us what is your contention?
Your Lordship, he has 5 criminal antecedents which he has not disclosed in the synopsis, which is
You know
again.
that, madam, please 406.
Your Lordship,
case.
he has,
Keep it
so,
for a long time.
Your Lordship, the trial is not going ahead only because he's in Jaipur court for another, he's there. He's not in our, if the Lordship may have the custody certificate. In the Delhi prison, he's only been there for 3 years.
Where is the custody certificate?
It's part of the SLP, Your Lordship, page 135.
Yes, custody certificate.
This to certify that as per jail records, inmate namely Ravi, son of so-and-so, resident so-and-so, was admitted in jail on 11/10/21 in case FIR number so-and-so under section 406, 409, 420, 120B IPC, PS EOW Delhi, and afterwards he was sent to outside court production at Jaipur court, whereby the Honorable Court of LDM Jaipur ordered to keep the above inmate in Central Jail, Jaipur, Rajasthan, in case FIR number so-and-so on dated 25/12/24. Since then, the above inmate is not readmitted in this jail as on date. The total period of incarceration in Delhi prison in respect of the above inmate in FIR number so-and-so under section 406, 409, 420, 120B IPC is from 11/10/21 to 20 and 15 days, Your Lordship.
Milord, may I please only highlight, Milord, one thing at page number 112, please, Milord. Milord, page number 112 is the part of the charge sheet.
Your
Milord,
Lordship,
may
part
kindly
of the
see.
charge sheet also includes that he was the authorized
Milord,
signatory
Milord,
of the
please.
company against which 156
Ma'am,
complaints
please permit me that my
Magnificent.
petition. Milord, page number 112, Milord, is the list of the cases. During investigation, following below mentioned cases have been found to be registered against Gajanan Kaushik, Ravi, Rajesh Kumar Laura. Milord, 5 common cases against all the accused persons. My co-accused Rajesh Laura has been granted bail. Milord, who was the main conspirator, who was Milord posing himself as the CMD.
Your Lordship, Rajesh Kumar Laura did not have section 409 against him.
Milord, that's true, Milord. Milord, but my
409,
right to speedy
it's
justice
admitted
has
that.
been, Milord, my
Milord,
right
may
to
have
speedy justice has been
55.
violated in this case.
Please, one by one. Eh?
Your Lordship may have
Ma'am,
page
please permit
55
me
of
to
the charge
complete.
sheet.
Milord, may kindly permit me. Milord, my right to speedy justice has been violated, Milord. Milord, there are 152 witnesses. Only 3 witnesses till date has been examined in chief. Milord, I'm sorry.
132 or 152?
Milord, 152.
152, Your Lordship.
Yes.
Milord, 152 witnesses, only 3 have been examined in cross. No cross examination has been done. Only chief has been done, Milord, for 3 witnesses. Milord, like this, Milord, I will be kept under custody, Milord.
Done by you, sir.
Milord, I'm sorry.
Cross examination is to be done by you, not by any other.
Milord, I have not been produced in the court.
Your,
For more than, Milord, nearly 10 dates, Milord, nobody's...
Not been produced in the court. Any document to that effect?
Milord, there are order sheets, Milord, I can bring them on record, Milord. Milord, as the state has submitted, Milord, I am lying in Jaipur jail.
Whatever it is, sir, whatever the argument you are advancing, at least that must be on record on the basis
Milord,
of some...
Milord, today I am only on the sole argument, Milord, my right to speedy justice has been violated, Milord. Milord, this honorable court in the matter, Milord, SLP criminal 7416 of 2026, Milord, has held, Milord, Vaibhav Singh versus State of Uttar Pradesh. Howsoever the grave offences, Milord, when Article 21 is impeached, when right to speedy justice is violated, Milord, bail should be granted. Milord, this is order dated 29/4/2026 by Milord Justice J.B. Pardiwala.
Okay.
Your Lordship, if I may.
Anything else?
Milord, on the delay part, Milord, last thing, Milord, on the delay part. Milord, may kindly see page number 4 of the impugned order, please.
पापा आपको नहीं लग रहा कि वो क्या बोलते हैं दोनों पंखों का वो खराब हो गया कंप्रेसर उसका तो बिल्कुल ही नहीं चल रहा जो भी यहाँ ये पैसा रखने
Your Lordship, if I may. The delay in trial is because of multiple reasons. Your Lordship may have the counter affidavit. We put that on record.
Milord, High Court has dealt with the delay at page number 4. Milord, para number 10 of the impugned order. Milord, para 10 I am reading at page number 4. As regard the delay in the trial, the same is explained by learned prosecutor on the ground that order of framing charges was challenged by Rajesh Kumar Lara by way of revision petition and the matter remained pending there. The prosecution evidence commenced on 24/6/2025 and by now 3 witnesses have been examined as per IU. Further delay was also caused because supplementary charge sheet against 2 persons who have responded were also declared proclaimed offender was filed on 21/8/2023. Now, my lord, here the charge was framed, my lord, in 2023. My lord, page number 119, annexure P4. 4/8/2023 is the date of framing of charges.
Your Lordship, after that, there is a history. One of the accused had challenged the order.
Madam, why you are speaking?
No, no.
Please explain that.
My lord, this is
I
Is it
apologize.
a mannerism, sir?
I apologize, Your Lordship.
Please sit.
Beloved, first charge was framed somewhere in 2021. Beloved, one of the accused, Rajesh Kumar Lara, challenged. Matter was remanded back for reconsideration. Beloved, annexure P4, page 119 is the order on charge. Beloved, this is the second order on charge dated 4/8/2023. Beloved, may kindly note here, page 119, bottom, the paragraph, beloved. Argument on point of charge is heard qua Rajesh Kumar Lara. Beloved, this petitioner was not granted the opportunity to argue also. Beloved, may kindly note this. Beloved, the last paragraph, please, page number 112. Beloved, I am reading from 121 bottom. Therefore, I am of the considered view that there was a criminal conspiracy between all accused persons and there is sufficient material to frame against accused Ravi, Gajanan, Rajesh Kumar Lara, Star Global Star so and so, and below charges were framed. 420, 409, 120B. Below, may kindly peruse the entire order, my lord. Below, the arguments were not advanced by this petitioner, my lord. Below, what a prejudice.
Yes. That is all?
That's it, my lord.
Yes, please. What do you want to?
Your Lordship, with respect to his argument that he was not given a charge, Your Lordship, he has not challenged the order framing charge.
Madam, if one accused challenges an order of framing of the charge and that case proceedings remain pending, then the High Court observed that the order of framing of the charge was challenged in the challenge. Therefore, there is no delay on the part of the prosecution. Can it be a ground to dispel the delay?
I'm obliged, Your Lordship.
So
Apart
this
from
meaning
that,
why this region as assigned by the High Court is not justified?
Your Lordship, there are
I think you
multiple.
will agree of it.
I am obliged, Your Lordship.
What do you want to say?
But there are multiple reasons, Your Lordship. There were other accused who were absconding. There was supplementary charge sheet.
Suppose other accused are absconding. What is the fault of this man? If other accused are absconding, so it is your fault. Your prosecution agency is unable to get them.
Your Lordship, kindly peruse the magnitude of the case. There are 156 complaints all over India against.
Maybe, madam, what
Your Lordship may have the charge sheet.
so meaning thereby after 4 years will not grant the bail, after 3 years will not grant the bail.
Your Lordship,
in 406 cases.
I
We are failing in our duty, ma'am.
Your Lordship, I'm obliged. However, 409 is a life imprisonment punishment. He has 409 against
Does it
him.
mean, madam?
There are clear evidences against him, Your Lordship. There is a signed lease deed which he has filed of the
Yes,
office
I'm not doing in the
premises.
High Court in the manner in which they passing an order. We should have passed an order against him, even structures against such judges. Not considering the things in the right perspective. They have to understand what they are doing. And every day Supreme Court 15 bails, per week 450 bails with every bench. Supreme Court has become now a court of bail.
I'm obliged, Your Lordship.
Okay. Hearing on it for the parties. We find. Parties, as per custody certificate, we find that in the one case, petitioner was brought in custody 11/10/21. It's same to in FIR number 412 of 2022. Registered by PS Jatwala, Jat. Thereafter, he has not been brought to the custody in this case. Primarily, it appears from the said custody certificate that his custody is of 3 years and 2 months in this case. So far as the other cases are concerned, we cannot embark upon the facts of that case, but looking to the facts of the present case in which the charges were filed on 4/8/23, and by this time, only 3 witnesses, 3 out of 152 witnesses have been examined. Please stop. Petitioner counsel contends that he has not been produced from the custody to the court. On the other hand, counsel for the respondent submits that the delay is on account of the accused persons because they are not cross-examining the witness and the other accused persons are abstaining. First of all, after hearing learned counsel for the parties, we find that in a case where the charge against the petitioner has been framed on 4/8/23, and only 3 witnesses have been examined on which the cross-examination has not been done. Full stop. The endeavor ought to be taken by the prosecution to conclude the trial at the earliest, and if within a period of 2 years and 10 months, only 3 witnesses could have been examined, such delay cannot be attributed to the accused. Please stop. In our view, the findings recorded by the High Court is not justified, and without going through the material facts. Please stop. In this view of the matter, at present, we are without expressing any.
Your Lordship, if I may, Your Lordship may record the appearance of learned ASG SD Sanjay in this matter for the respondent. Your Lordship may record the appearance of learned ASG SD Sanjay in this matter. I'm appearing on obliged. Your Lordship.
Just not for.
May it please your lordships. Lord, this coming up after notice, my lord, in this case, 6 years have been passed, my lord. The petitioner is in custody, my lord. Charges are framed 2 years back, my lord, in August 2024. And out of 92 witnesses, my lord, only 7 have been examined, and those all are, my lord, the formal witnesses, I mean, punch witnesses. And most of the accused persons, my lord, have been granted
Supposed
bail.
to examine 40 witnesses because there are 4 eyewitnesses which will be examined. Next, only punch witnesses have been examined.
Denied you to examine, sir. Period of custody 5 years, 9 months,
Yes.
10 months by this time. And you see, total his role is not specifically specified.
Yes, ma'am.
Unlike no specific role has been assigned. Cause of death is assault by means of a sword. So what we can do now in such a situation? What we can do, sir?
But in the supplementary statement, where the complainant said that he had a sword, although there are 53 injuries. It's,
Maybe, sir.
yes.
But at present, what we can do? And considering the fact that no specific role has been alleged except to state or execute some to improve the statement in subsequently by the complainant. In addition, the period of custody is more than 5 years and 10 months. And by this time, out of 92, only 7 witnesses have been examined. However, delay in trial not be ruled.
The trial may be expedited. No, this only take. Only directions trial may be expedited.
Will be expedited. Trial will be expedited within a period of
2 year, 2 year, 2 year.
Grateful.
But the lordships are granting bail, my lord? You don't want, sir? I'm sorry, I could not hear that.
Grateful.
Great.
Lordship, in this matter, the petitioner was originally charged under 489B and 489C, and he was explicitly acquitted under 489B.
It is 489C.
Lordship, mere possession of the counterfeit notes. And Lordship, the state has already filed the counter. He has already undergone, Lordship, 1 year, 11 months and almost 28 or 29 days. Lordship, fixed period,
2 years.
almost 2 years, Lordship, and fixed
More than
period,
2 years.
more than 2 years.
Out of 5 year, 2 year.
Please, my lord, out of 5 years, 2 years, my lords. She says that there is no antecedent. Subsequently, there is a gangster's FIR, my lords, with base offence, my lords, only under this section.
Lordship, which was invoked subsequently after the sole case.
After hearing and a complete petition, and considering this fact, the conviction of the appeal is only under section 489C of the IPC, acquitting on the charge of section 490, 489B and 489.
489B, he was acquitted, and 489C survived.
Thus, out of total sentence of 5 years, 2 years has already been served by the total वाला time. 2 years only been served by in such circumstances without expressing any opinion, subject to final outcome of the appeal, pending before the High Court. The substantive jail sentence.
Grateful, Lordship.
Please, the lordship.
Lords, the state has filed counter, my lord. The charges are yet to be framed. All the other accused who have been attributed the role of stabbing have been granted bail, my lord. There are 47 witnesses, 14 material objects, my lord. Charges still not framed, and I've been inside for 3 years, 3 months now, my lord. My lord, the stab injury has been
Lordship, they have been on bail. One of the accused is now absconding. So the trial court has issued non-bailable warrants against him. This is the main reason why the charges are not framed. So, and he is not, he is specifically named in FIR, but I agree that all the other accused are on bail, but the delay is attributed to the accused persons who are on bail.
The role of this man is of stabbing by means of knife over the chest.
Yes.
Yes. The statement indicates that everyone who has been granted bail has.
No, it is not like
Yes, I'll read the sub.
everyone who is granted bail, they also stabbed by means of knife, but on the backside.
Milords, I'll just read the supplementary statement at page 34, Milords. In fact, Milords, the death occurred after 30 days of the Milords, during the course of the treatment, Milords. He died after 30 days. Kindly update page 34, Milords.
Yes, sir.
Lordship, I'll leave it at that. He is the prime accused, but there is delay in framing of charge. The reason I tried to
25 to 30 days death is.
Lordship,
So you can understand what may possibility. We don't want to say now custody is more than 2 years and by this time is 5 months.
yes, sir.
2 years, 3 years.
3 years.
What can we do?
Lordship, my only request that he should cooperate with the trial because the other accused are not cooperating.
So he will appear without leave.
And
will not go.
yes, and Lordship may expedite the trial also. One line will.
After hearing the evidence from the parties of claim. Considering claim, we find though the rule has been assigned of assault to the accused. However, the death of the injured was after 25 to 30 days. By this time, the custody is within 3 years and 5 months. Full stop. The charges have not yet been framed. Considering all these circumstances without expressing an intelligence certification.
Very grateful, Milords. Very grateful.
Please, madam.
Yes, sir.
Counter could not place on record, but I have the
physical copy, if my lord may permit, I can extend it.
Yes, what is there? What is there, please? There is a. We'll take it during vacation, we'll be, then we go to, during vacation. It be placed on the list during vacation.
Please.
Yes.
Milord, PRS, Milord, dismissed by the session judge, allowed by the High Court only on the ground that the evidence is documentary in nature. Your Lordship will just see the FIR for a minute.
Yes.
And the second point ultimately is, Milord, he does not disclose his criminal antecedents. But before that, please see the FIR, Milord, at page 30. And if I may invite your Lordship's attention to, Milord, middle of that page, somewhere it starts subsequent to the completion. Lordship has, Milord, para number 12, right in the middle of para number 12, subsequent to the completion of the auction process.
Why we should interfere in this?
Milord, because
Which is based on a documentary evidence.
it is not, Milord, because I am the liquidator.
Yes.
Milord, I find out that 54 acres of land has been taken over by the government. He receives the money.
Whatever it is.
Milord, he receives the money. He is not in charge of the company. He receives the money. He pockets it, all of it. Milord, we don't know where the trail of money has gone. And secondly, Milord, he does not disclose his criminal antecedents. There is a public fraud of 306 crores by him.
Yes.
So, Milord, ultimately,
Because I am appearing on behalf of the state, Milods, on advance notice.
Somebody is for IQ. It is issue notice
grateful.
to the respondent number. What? To accept notice on behalf of respondent number 2. Mr. Respondent informs.
Grateful.
Your Lordship, I am appearing for the petitioner. At the time of the commission of the alleged offence, the petitioner was 7 years and 7 months old. And Your Lordship, the name of the petitioner is neither in the FIR.
Lordship, the petitioner is in jail under section 20B subclause C and 25 and 29 of NDPS Act.
What is your period of custody by this time?
It's 10 months, 4 days.
It is too early.
Lordship, my submission is the petitioner has been falsely implicated, which is apparent on record. I can show before your Lordship. Lordship, the petitioner had started his journey from Lucknow to Sambalpur in Odisha and he was returning back. In vehicle number UP 32 HJ 9999. This was his vehicle which he was driving. He was a driver.
What is the proof of this?
Lordship, I have annexed the FIR and the charge sheet which Lucknow police has filed.
That is just a plea to take a plea of LIV. You have done all this.
Lordship, my submission is from the very beginning. I was driving this vehicle itself.
Too early, sir.
Lordship, in fact, the Lucknow police has.
Too early.
Lordship, my submission is that this is the clear case. Two more cases, Lordship. They have not complied. Provision of 105 of BNSS. No audio videography. Nothing. Even the seizure memo which was prepared, Lordship.
The quantity is coming to 131.5 kg of ganja.
Two vehicles. In my it was 87 kg.
This is just a nothing.
One submission, Lordship.
Yes, please.
They have prepared. They say that they have prepared the seizure memo on the spot. It is halfly in typed memo and halfly in handwritten memo.
At present, we can't do all these things.
Lordship, but the submission is I was not driving this vehicle at all, Lordship. This is my submission.
We have put a first question to you.
Lordship.
What is the proof? So you can say that document. That document is a LIV only for the. We have seen that.
Lordship.
Nothing. You see, after hearing At present, we are not inclined to.
But at this stage, it would come.
We are saying at present, we are not inclined to entertain the present itself according to dismissed. However, after serving about 9 months, the petitioner is at liberty to apply for High Court.
Much obliged, Your Lordship.
Please, my lords. My lords, the only piece of evidence against the petitioner is the oral testimony of the owner of the godown, my lords.
What is required? What more is required, sir? Oral testimony.
My lords, but there is no rent agreement, no rent receipt. The co-convict who was apprehended at the spot, he has been granted a suspension by the High Court, my lords. Against me, there is the only oral testimony of the owner. Moreover, he has not proved that he was the owner also, my lords. No sale deed, no rent agreement.
Occupant of that premises where the recovery has been made.
Please,
And now only period of custody 2 years and 10 months out of 20 years of the sentence. We can understand if you have served minimum of 5 to 6 years, we can understand.
my
Because
but there is
the
no
sentence
recovery.
may be reduced from 20 years to something. But for all angles, this is not a case to grant a suspension of sentence.
My but there is no recovery from the petitioner and
Not a case in which the suspension of sentence can be granted.
my lord, that is there, my lords.
At present, we are
But
not
then I will withdraw at this stage, my lords.
at this stage, counsel for the petitioner gives permission to withdraw. Yes.
Alleged.
There is a letter, sir. Your Lordship, I'm seeking adjournment. There is a letter circulated. And the arguing counsel is not well.
Rajesh,
Arguing
you are
counsel,
well? You are well or not well?
I'm,
Rajesh? Are you well or not?
I'm well.
I am well, then make your submission, sir.
Your Lordship, I'm.
Make your submissions. So are you accepting, madam?
Yes, Your Lordship.
So accept the counter will file within 4 weeks. Yes.
Obliged.
Yes.
Please, Lords, this is an anticipatory bail, my Lords. I was implicated solely on the basis of disclosure statement. I was implicated solely on the basis of disclosure statement. I was not named in the FIR. No role or overt act has been attributed to me, my Lords. No recovery has been effected from me. And most importantly, my Lords, High Court and Sessions Court wrongly observed that canter vehicle in which kettles were there. I was following that canter vehicle in my Brezza car.
You were doing since January 24. What you were doing?
Notes. I can only say I was not advised in the time.
Now rightly advised. Huh? While rightly advising, have you not asked this question?
Hold on, my Lords.
Lord, charge sheet is filed against Lord 5 accused person. Investigation against him is pending. And Lord, page 36, the FIR, his name is Lord there, that he absconded from the place of occurrence.
There is nowhere mentioned, Lords. I was absconding or.
There's one more submission, my Lord. There is.
Please answer. That is the first question to you.
Hold on, my Lords.
January 24. Now we are in May 26. Where you were? Person want to take a benefit of the anticipatory bail must come with this all clean hands. After hearing when it comes to the petition, we are not inclined to grant the pre-arrest bail as per for by the according to this question.
See,
Lord, the man is in the hospital. He was to undergo angioplasty on 20th May. But because of the pulse being too low, he has not been able to undergo the procedure. And the High Court has directed him to surrender today. Now, even if the angioplasty had been done on 20th May, he needs time to recuperate. Please have the impugned order. The order is of 15th May 2026. Medical documents have been verified. I suffered a heart attack on 16th of April.
Plus, he
I'm in
was
the
to
hospital.
undergo angiography, not angioplasty. The angiography, let the angiography report come, my lord. If the reports indicate something, well, it's only a outdoor procedure, my lord. It's not required hospitalization, my lord. Let that report come, my lord. If the report indicates that something for which he requires hospitalization, we will not insist for his.
You did angiography?
Sorry, beloved.
It was to be taken on 20.
Angiography done or not there?
No, it is not yet done. He is in the hospital right now. Well, may I have a humble prayer. I'll surrender on 30th of June.
Judge, who told you that you should not go for angiography? We can understand if angiography done and the blockage were there, then angioplasty did, then we can understand you can ask for 2 weeks further bail. But why at this stage? Why you have not done angiography on 20th of May?
No, because the pulse is very low. He is currently in the hospital. I have a humble submission. Well, after all,
They will take care.
well, as against 20 years, I have undergone 8 years in jail. The prosecutrix is not appearing in the court. The appeal cannot be heard. All I am saying is, I will surrender on 30th of June.
You did it.
Whatever may happen.
Whatever the procedure you do within 2 weeks.
Very well, very well, very well, very well. Grateful,
Lord.
grateful, grateful.
The net profit for the petitioner and extremist, yes. But the petitioner has to undergo the angiography, which could not be done on 19th and 20th of May 26. Since the pulse was low.
Please.
Listen. However, considering the facts and circumstances of the case, the petitioner is at liberty to undergo the procedure within 2 weeks.
Please.
Otherwise, he has to surrender.
Please.
Or not before 10th of May, 10th of June.
Yes.
Full stop. Okay. Full stop.
No, please.
With your personal observation and interim protection, the date is specified. The parent has simply still disposed of.
Grateful, grateful.
What are the out of an order protection?
Those item 18 belongs to a batch of RSCP now.
RSCP का जो batch क्या है ना
8 to 7
back करना only right. Delay is a 11142 only that. Item 19.
Lordship, in this matter, the High Court on 1st of September granted issued notice, and thereafter on the 6th of October they asked for instructions from the private respondents as well as the NPCL. But later on the 14th November they dismissed it, saying that the only added parties are private respondents, and hence no repetition is liable. Lordship, may please come to page number 57 for a moment. Lordship, bottom fourth line. The electricity ombudsman directed the NPCL, the public sector company, to observe the directions of UP electricity code, and thereafter we approach the rate against the NPCL only. And High Court after 2 days say it is not maintainable despite issuing the notice and asking for directions from the respondents.
Delay control is to go.
All right.
Not in this case, not the Honorable High Court has relied on a judgment in
Megha case, that has been referred to a larger bench. If Lordship may permit, I can pass it on. Not the. Please,
Your Worships. Your Worship, in this, my lords, is a dispute between the my lords, members of the my lords, one society, my lords. There are 5 buildings, my lords. 1 and 2, my lords, got acquired, my lords. They have got their compensation for the land and the flat also, my lords. Now, my lords, they are now again after receiving those compensation, my lords, they are saying that the acquired the remaining land should be divided and that the new body has to be formed.
Wrong in this. Bifurcation is permitted.
Malus, my submission.
17 and 18. What is wrong in this?
Malus, what is happening is this, Malus, that the Malus, the remaining land is Malus have the compensation be distributed again amongst the society members, the whole as a whole, because the land belongs to the Malus, the fundamentally the society as admitted.
It is not a case. This may simply see the case whether bifurcation is done is right or not.
Correct, Malus. So, Malus, the bifurcation, Malus, the deputy.
Under the statute, the bifurcation is permitted.
Correct, Malus.
So, whatever the amount you can proceed, you can receive the whatever the proceed for that bifurcation.
Bifurcation.
You can object of it.
Malus, bifurcation is after date compensation has been received, Malus, earlier, Malus. Now, Malus, one set of members of building 1 and 2, and after receiving the compensation is coming.
No,
Yes, sir. If I may assist your lordship, is my
not denied to assist.
Yes, sir.
What you will assist now?
Yes, I will invite the Honorable Court's attention to P7 for a moment. Yes, I just want to show 2 lines from that. Yes. P7 at page 126. Yes, it's an indemnity bond cum consent agreement given by the flat owners. Page 126, middle of the page, second last para, where it says executes this indemnity bond. The next para, explain to us the benefits of the consent award. In view of all this information, we have been informed that the estimated market value of land and building therein as rupees so and so of the said property, or out of which the land compensation comes as rupees so and so. Does may kindly come to the next page, Mulaz. I'm so sorry, 128, Mulaz, para 9 of this. Page 128, para 9, we will never claim additional compensation under section 64 of the Acquisition Act. Also, we do not rely on the terms mentioned in other courts. We guarantee in writing that the flat owners, our heir, will not file any appeal against the decision regarding the acquisition of the property. My submission is this: once they have received the entire compensation, including the land as per their own consent agreement, do they have any remainder right in the land which belongs to the society? And that fact is not disputed.
Malus, there is a Malus delay, Malus. Please.
So there is otherwise way to bypass the orders of this court.
No, my lords.
Oh, this is the way.
No, my lords.
No, sorry.
I'm sorry, my lords.
No, sorry, sir. You see the order. What order we have passed?
Please, my lords. Last order, my lords have directed that this entire list be prepared on merits.
Yes.
Only to the remaining seats.
Yes.
So I will
So
be
now
affected.
after coming, you wake up and you come here.
My lords have said that
We can't do that.
those persons who
Nothing can't do
have
anything, sir.
been before the High
We have
Court
not opened the Pandora box.
and those people whose petitions have been
No, sir.
dismissed.
We have not opened the Pandora box for anyone.
Lords, kindly see.
No reason.
This
Either
is
you
the-
withdraw, you want, wherever you want to go, go. But here we will not entertain such petitions.
My lords, my only
We see no reason.
lords, allow me to withdraw this.
Thank you.
Allow me to withdraw them
Senate Council 6
with liberty to avail available remedies.
present petition with liberty to take recourse as punishment.
My lord, in this case, these petitioners are selected way back in 2018. My lord, as per the qualification prescribed in the advertisement. My lord, their writ petitions allowed by learned single judge.
my lord, now division bench remands the matter back, my lord, because after Supreme Court, my lord, there are two orders which are passed by the Supreme Court. My lord, one of the case, my lord, the Supreme Court remanded the matter back, my lord, to the High Court. And again, my lord, matter has been decided by holding they have a valid qualification. My lord, now since 2018 now, my lord, now they are made a shuttlecock between, my lord, single bench and division bench. The matter stands concluded. I request that the matter may not be immediately sent to single bench, so we will decide. That's my request.
Let the notice, we will fix a date in the last week of July and we will.
Honor, grateful.
Notice on stay also.
May it please your lordship. My lord, I have served 23 years and the single judge has correctly directed matter of regularization. Again and again, there have been number of people, my lord, they have like, there are vacancies of 13, 12 are regularized. I am the only one discriminated against. And what does the High Court say, my lord? It says, my lord, may I request stay of the order also, my lord?
I beg to appear for the caveat, first respondent caveat. My lordship may make my submission. But he was relieved on 13/4/2026. Yes, sir.
Are you working?
Not on next month, he has been relieved on 13/4/2026. Therefore, there may not be any statement, we file our count.
Mr. Satyanarayan, in the
Yes,
meantime, the improved notice shall remain still.
My lord, there is a small delay in refiling, my lord. Deeply obliged.
Deeply obliged.
The petitioner was suspended without opportunity of hearing. For the period, he joined the services on 20.
What can be done?
The petitioner joined on 20th of August 2000.
Whatever it is.
But the suspension order has been passed because the rules without opportunity of hearing.
How suspension can be required?
But the rules provides that
Even need not to issue a notice for suspension. And
no,
High Court
no,
has kept
they,
it in-
they issued the notice, but it was not served, and immediately I submit my reply on the next day.
Case for improvement. Anything else? Thank you. No reason.
Please. It's my VRS scheme specifically stipulates minutes. On 4th of November, I have issued the notice minutes, circulated the scheme. On 7th of November, I said that increment is not available.
Delay condone issues.
Minutes lordship will stay the, they are filing contempt minutes. They are filing
Let
contempt.
me file, then you can ask then at that time.
Lordship,
Instead present, sir.
much.
That's it, the High Court, on one hand, they directed that there is no infirmity in the order passed by the tribunal, the High Court has said that the tribunal has rightly directed to engage forthwith, my lord. But in the concluding parameter, Lordship, High Court has said that whenever the vacancy will arise, my lord. As per the seniority list, my lord, I am running, I am a poor person.
Questions. 2-3 questions to you. Can we ask?
Yep.
We are audible to you.
Yes.
You were selected, you were within the list of the 12 persons of selected.
Yes, yes, your lordship.
9 verification done, 3 verification not done, you fall within 3.
Yes, I am also one of them. Police verification was not done.
Please listen.
Yes.
Please listen.
I am sorry, my lord.
Out of these 12,
Yes.
9 verified. So, if we see the list of 12, what is your position in the merit in that 12?
Yes, my lord.
Is it 9 were those who is from sequence 1 to 9, or 9 were those who is sequence 1 to 12? Out of them, some of them was there, and you are the person who fall within any of the person who is above than you.
You also did, but
We have not taken no such plea like this.
the High Court is
Can
said.
you understand our query, sir?
Yes, yes.
What is our query? If out of 12, if below 2 you have been appointed from that merit, then you may have a very good case, we can understand. No pleadings are this like this. Nothing is there. Neither the reply is there to that effect. Petition, then we will consider. But please come with a proper case, sir.
Then not the liberty may be given so that I will place
Petitioner
the
pays for and granted 2 weeks time to file the additional affidavit documents.
obligement, deeply obliged.
Stop the work.
Obligement.
Your Lordship, 28 has been dismissed on grounds of delay, Your
What
Lordship.
is wrong?
There is,
How much delay was there?
there was 388 days delay, Your Lordship.
388
However, Your Lordship,
Period of limitation was?
writ appeal, Your Lordship.
It appeal, what is the period of limitation prescribed?
Your Lordship, 30 days.
Then what is the reason of prescribing a minimum limitation?
Your Lordship,
Because from one court you have to go to another court.
Your
You are
Lordship,
representing in one court, you have to go in another court with a representation. And you are at 388 days of delay.
Your Lordship, meanwhile, we have implemented the order. The High Court passed 2 directions, Your Lordship. One,
And implemented, then why
Your
you are
Lordship,
here?
there is a difficulty, Your Lordship. The High Court asked us to appoint the less meritorious petitioner who was before the High Court, Your Lordship, and also accommodate the other candidate, Your Lordship. Now, there are no vacancies, Your Lordship. We have implemented the directions of the High Court only with respect
What is
to
the date of implementation of those directions?
11th June 2025, Your Lordship.
What is the date of filing of this WA?
5th December, Your Lordship.
Why have you, while appointing, have you taken any pretext? Have you mentioned in their orders that we are issuing the orders of appointment subject to item to which we are taking recourse for filing of the writ appeal?
Your Lordship, we are not may I please we are not challenging his appointment, Your Lordship. Here there are 2 directions, Your Lordship. One was to appoint the petitioner. We have appointed the petitioner. The other direction was to accommodate the other candidate as well, Your Lordship. Our challenge is limited to accommodating the other candidate as there is no vacancy, Your Lordship.
Appealing on behalf of the petitioner submits that the order passed the petitioner in the case. Petitioner before the item developed. In the case before the item has been implemented. However, the direction issued to accommodate other persons is unfulfilled. It is urged that the writ appeal challenging such direction was filed with some delay after implementation of the order for the petitioner complying the order of the High Court. Full stop. Therefore, to such extent, full stop. Considering the aforesaid, issue notice.
I am obliged, Lord.
Behind. Well, so however, the writ appeal was dismissed on the ground of the.
But in this case, though against the same order, notice has already been issued and status quo is there. 83 OAs were filed. They only filed 5 writs in the High Court. Though in only 5 cases, judgment was reversed. Our case they never challenged. Now on the basis of that, they have started issuing show cause notices to us. So therefore, we have filed this SLP challenging that judgment with permission to file SL. Otherwise, on
Issue notice. In the meantime, status quo permission का कर देना, permission का issue notice. Mistakes are taken then. In the meantime, status quo as it exists.
No, they have issued further proceedings in pursuance to the show cause notice may kindly be
We
stated.
are saying status quo
As it exists.
as it exists today.
There is a 92 days delay because we had permission to file, and permission your lordship will have to allow.
With everything.
All right.
Anything else, sir?
No, that's all. Great.
Please, madam.
Yadav sir,
Please, madam.
delay. We have to dismiss on the ground of delay.
Lordship, at least your lordship kindly consider everything considered by the learned tribunal as well as Honorable High Court in lower side.
No, sir, you were sleeping over
But
418 days of.
they are very poor people, your lordship. Even I am, yes, your lordship.
Poor
Very
people?
poor people, therefore, your lordship. They are not in position to knock the door, your lordship.
What is the salary calculated for you?
10,000, your lordship. That has not been
No, sir,
considered.
that is the basic problem. You kindly look into the judgment.
Please. Kindly, your lordship, consider.
Would you waive this interest? Would you waive the interest for this period?
Yes, your lord.
Huh?
Wait. I will leave it,
The
your
lead
lordship.
counsel for the petitioner submits that he is ready to waive the interest for a period of delay
Please.
in case the enhancement is granted by this court. Full stop. We take the side statement on record. Full stop. Issue notice
File.
on delay as well as court.
My lordship, in this matter, we circulated adjournment letter. Grateful.
In this case, may I invite your lordship's kind attention to page 52.
State council first. Call state council.
Hello.
State of UP के वकील को बुलाएं.
So this need to be checked, madams.
Notice paper. पीछे लगा.
Detailed documents.
There is a letter.
Lordship, I am requesting for a pass over the main counsel on the other courts. My lord, there are glaring inconsistencies, my lords, in the statements of the PW2, my lords.
Yeah.
PW2, 3 and 4, my lords.
Yeah.
PW2, my lords, may I read, my lords? A1 took me to the kitchen, removed his clothes as well as the midi I was wearing at the time and sat on the top of me, rubbed his genital organ over my genital organ for some time. After about 5 minutes, he got up and left the place. When I was in the I've been in custody, it's been more than 12 years.
Issue notice. Delay convert. Issue notice. On merit as well as full sentence.
Obliged, floats.
Come with instruction. Go by the old provision, unamended provision.
These are the old provisions, my lords. Offences of 2012. I'm grateful, my lord.
That will go till sentence undergone.
Please, my lords.
Next day we'll.
Obliged, my lords.
This is a delay of 132 day delay. The petitioner's clearly stated in his FIR and as well as in 163 statement, the involvement of all the respondent accused persons. I could also observe that page number 5, Milan. Paragraph 8. No doubt, as rightly confirmed by the learned counsel appearing by petitioner in his complaint as well as in the statement under 161 CRPC has implicated the involvement of the respondent 3 and 5. Moreover, at the time of admission in the hospital, he has stated before the medical officer that he was attacked by fourth person. And the petitioner has clearly attributed all the vote act of the respondent, my lord. He is 72 years old in all the records, my lord. Kindly page number 19, my action register is there. Stay, my lord. The trial is going on trial.
What we can do, sir, at present, without hearing, it's a case of a discharge. Then what we can do? Let us come, let them come, then we consider. We'll consider.
Obliged.
My lord, the order passed by the Honorable High Court is absolutely ill-reasoned order, my lord. My lord, may kindly see page 10, paragraph 15. No
allegation.
No reasoning, my lord.
No allegation, madam.
My lord, may kindly see. My lord, may kindly see the FIR.
Don't put every family.
My lord, there is no question of. My lord, after the marriage, the husband left for Germany, my lord, for 1.5 months. The wife used to stay with the in-laws, my lord. There are not only
between that period of in-laws. No.
Yes, my lord. There.
No.
My lord.
That period. No.
May I read the?
Kindly read. Yes, you read.
Yes,
you read for yourself, ma'am,
yes.
please.
Page 33 is the FIR.
Kindly read. We are not denying of anything, madam.
Yes, madam. And page 37 is the FIR statement.
Nothing is in the FIR. When statements come, then you started alleging everyone.
My lord, no, it's not correct, my lord. My lord, page 37. Page 37 for a moment.
These poor fellows, eh?
My lord,
nothing is there.
my lord, but what is the reasoning given by the Honorable High Court? Absolute. My lord, I'll just read one paragraph given by the Honorable High Court, my lord.
Thank you, madam.
Which are the facts and circumstances of the
Thank you,
case?
madam.
Not even a single.
Thank you, madam. Thank you.
Obliged, my lord.
Yes.
Well, despite the claim and counter claim of both the parties, my lord, the supurdagi and custody was given to the complainant beyond the purview of 451 because there is no ownership. Moment, my lord, we say that the property ownership is already attached. It is admitted case that part of money is paid. So, moment is admitted by the seller that part of the pay is paid and the rest of check could not be placed on record and for the bank encashment. So, right to get included one. My lord, accused.
Yes.
I'm saying accused, but
yes.
Ownership right is intact with that. I have paid the money. It's admitted case.
All directions have been issued. All security.
But my lord, admittedly, this gold is 5.80, and the valuation was done by below the 3.6, and this Suburdinama was filled for 3.6. Then all the money, I am saying that it is my family ornament, my lord. And why? I am ready for joint possession. No issue. Even trial court, but not to be the complainant. Indirectly, it is given the supurdagi to the complainant. Complainant has no ownership. Complainant himself is saying that my money is not paid fully. That is the only grievance, my lord. When there is no ownership, only the right have the recovery only. They can recover the money by any way. This is settlement of account, my lord.
This is one of the way. They need not to go for recovery proceedings, and they will satisfy by this.
Well, maybe recovery, but my lord, 451 is says that ownership is right. I have this is my ornament, my lord. Then it may be joint possession. I have no issue, my lord. Possession has been given to the complainant, and the supervision is given to some banks. Where I am, my lord.
Nothing is there.
At least my joint possession may be given.
Nothing can.
Right to respect may be given, my lord. Anything may be given.
Sir, nothing, sir, in this case.
Great.
Lords, I am yet to obtain instructions, my lords. We tried to contact him. He is paralysis patient. So, my lords, I am awaiting instructions, my lords. We have not been able to contact him. My lords, I am for the respondent, my lords. He is a paralysis patient. May have it, my lords, after vacations.
My lords, this is probably a matter where, my lords, the railway had to file a status report. I think my colleague is mentioning some other item 40.
No, this very matter, my lords.
The issue is there in this case.
Item.
Sorry,
Yes, my lords.
there is one issue.
Yes, my lords.
Railway is relying upon some report of 11/7/2016.
Yes, my lords.
That is of the CBC report.
That's
the
right.
Final report of the CBC we have quoted in our order.
My lords, then your lordships had modified the order, my lords.
Satisfied to us that 16 report and the final report
Yes, my lords.
is which we quoted
Yes, my
in our
lords.
order.
Yes,
So,
my lords.
suppose subsequent report is there, final report, wherein some action has to be taken, then how you can rely upon some interim report of the CBC?
No, my lords, your lordships had modified.
This matter. So better is you may also look into this.
Please,
The other side may also be noticed. Then we will look into.
please, my lords.
Which is report received from the IRCTC by the officer being placed for orders. By the Pradeep Rade, Deputy Chief Vigilance Officer, Central Railway, has been placed for orders in furtherance to the previous order. In furtherance, indicating the compliance of the main order dated so and so 21/1/25 past 5 this code in criminal especially criminal numbers function. Full stop. This case it is required to be looked into that in para 3 in the general order the observations made by the CBC in the report has been quoted. However, the action taken report is based on the interim report of the CBC dated 11/7/2016. First up, ASC may look into all these facts and apprise on the next day. Full stop. The so and so petitioner be noticed in the meantime. Respondent be noticed in the meantime. Respondent of the original case, original SL criminal numbers one should be noticed in the meantime. Full stop. List after 6 weeks of further orders.
Congratulations.
No, apart from Niharika, where your lordship has said that the investigation should not be interdicted. Just have a look at the false statements in court. Let's just see, look at page para 4 of the impugned order.
Go there, yes, sir. You go there and
Just have a look at 8 minutes.
you go there and apply to the High Court, sir.
Just have a look at 8 minutes. I'll just show minutes what is happening.
Yes.
Just see, because this is the order passed after hearing me. Just see this. Para 4. The allegation is that
Dalal submits.
Mr. Dalal submits that subsequently, in order to clear the existing loan against the subject property, the petitioner cleared the dues owed to the HDFC Bank and obtained no due certificate on 27/3/26. That is subsequent to the FIR. Now just have a look at page 29.
Yes, sir.
That was in relation to some other property. Page 29. Lordship, just see this at this second paragraph.
This document was filed by you before the High
No,
Court.
no, this was filed by them before the High Court along with the this writ petition.
Go and point out this. to the High Court.
And just one more thing. Just have a look at this because this says.
Sir. Yes, sir. All this we are not saying anything against you.
Yes, ma'am.
What we are saying is arising out of an interim order.
Yes.
The material which has been placed before us
Yes.
will be brought to the notice before the High Court while applying for modification of this order. But the High Court may look into on the merit of all these contentions and pass appropriate orders.
And one more
Not
fact.
saying anything more, sir.
There's one more
But
fact.
you have to go for more facts. You go show more facts to there.
On the face of it is like that. Lordship, may clarify.
Rising out of an order. 16th of 2026. Passed by the High Court. Issuing interim direction. In particular, para 13 for the case. The present petition has been filed. Present SLP has been filed. And the senior counsel has various documents indicating the fact that the consideration has been made by the High Court. Consideration made by the High Court is not without looking into the document connected to those contentions. However, at present, we are not inclined to entertain the SLP and grant liberty to the petitioner to file appropriate application for modification of the order, modification of the location of the order. Yes. Before the High Court, along with the relevant documents. 11 pleading and documents. Based upon filing such application, the High Court affording an opportunity to the other side to pass appropriate order. First of all, with the aforesaid order, with the aforesaid of the petition, present SLP stands disposable. Great. 42.
It's by an unreasoned order, my lords, the whole trial has been stayed, my lords, against all accused. Only one accused has filed a petition against framing of charges, and the whole trial has been stayed, my lords. And this accused, my lords, filed a discharge which was dismissed, and then she has filed an application against framing of charges. And my lords, no reason whatsoever. Both the parties appeared before the High Court, my lords. Arguments were advanced. No reason is given why it has been stayed, my lords.
Apply there before High Court.
Because practically the trial has already been stayed.
Practically, we are not saying anything. We are only saying practically you go there and apply because.
Milods, I'll do that. Milods may pass it.
Against the SLP, against the interim boss. However, at present we are not entertaining this bill. It is suffice to say that if petitioner applies vacation of such an order, the High Court may consider the same, affording an opportunity to other side. This court will be opportunity.
Milods, one request, vacation stroke modification, if Milods may write, because there might be a
modification of the vacation.
Obliged. Wait, please, Lords. Lords, I appear in this matter, my lords. So, petitioner in person, my lords were gracious enough to appoint me as the amicus on 27/1/26. My lords, this is a miscellaneous application which has been moved for restoration.
Yes.
For restoration, my lords, the restoration application, my lords, MA was moved on 13/2/2024 of an order dated 8/10/2018.
Surprise to your client.
My lords.
What he is writing, the court is protecting their registrars.
My lords, I have informed.
What is this, sir?
My lords, I have informed. I have definitely, he's online, my lords. I have informed, I have advised him.
We do not afraid of anything, sir.
No, we bow down to that, my lords. I have informed him. I have informed him thoroughly. I have informed him thoroughly, and I told him that this is not right.
Tell us why you cannot go in the High Court.
My lords, the High Court matter, my lords, which they had moved, there was a typographical error which I have explained to him. There was 15/16.
Cannot go in the High Court, sir.
No, High Court he moved, my lords. He moved High Court. My lords, he moved High Court. He moved High Court. After the High Court, my lords, he filed a 32 saying that the High Court has incorrectly mentioned 2015 to 2016, which I explained to him.
Mr. Chopra,
My lord.
nothing makes any difference to that.
Then I leave it to my lord. I direct him to go to the High Court.
That we will hear him also. What do you want to say?
My lords, he's there.
Yes, please. What do you want to say?
Yeah, actually, sir, yeah, the typographical error can be acceptable. I leave to you, my lord.
And we are telling you, by the next time we will write like this that we want to protect the registrars and everything. All right, registrar's function is completely different. The court function is completely different. This is completely merely on this statement. Your action must be. This should be thrown out.
Okay.
It is not like this. You are litigating since beginning. You have seen everything.
Okay. In fact, I also pointed out that.
You are unsuccessful. And now alleging, pointing out the finger from to everyone. Introspect yourself, sir.
In fact, the MA itself has been moved after more than 100 to 272 days.
We are aware of this.
So that itself.
How this MA can be entertainable? Tell us.
I agree, my lord.
Recently we have said in one judgment.
Yes, I agree, my lord.
This is Pardiwala side of this judgment.
My lord.
Circular issued by this court.
I agree, my lord. I've heard that. I'm informed that this MA is per se not maintainable after 1000 days itself. How can this be moved also?
Nothing can be done, sir. Okay. After hearing the petitioner in person, as well as the amicus appointed by this court, they are not inclined to interfere in the proceedings. Mr. Kushner's accordingly. Nothing can be done.
My lord. I'm so obliged, my lord, for the opportunity, my lord. Thank you.
44. Yes, sir.
Is abrupt withdrawal. Sorry?
Since another duty, I may itself is not tenable. See, वो judgment लिखा था ना अभी मेरा भी judgment है इसमें से problem yes sir.
Sir, the reason for filing this petition is for abrupt withdrawal of my video conferencing rights at Family Court, Motihari, Bihar, and second, non-supply of order sheet copy, digital order sheet copy. In reference to that, I would like to point out
why you cannot go in High Court, sir?
Sir, because this is filed under Article 32. Because my fundamental rights under Article 14, 19 and 20.
Read Article 32, sir?
Sorry, sir?
Have you read Article 32?
Yes, sir.
What is required in Article 32?
If the fundamental rights have been hampered, I can approach the Supreme Court.
So, doesn't mean that every case must be entertained in Article 32 and that will still matters like this.
Sir, this is a state matter, but the governance has to be through the Supreme Court itself.
Because you don't have that much time to entertain such petitions. Would you like to go in High Court?
Sir, only two submissions from my side, sir.
You are asking, would you like to go in High Court? Otherwise, you will dismiss this.
Yes, sir. I would like to go
in High Court.
Only two submissions.
No, nothing doing. Okay. After hearing this petition,
at least
we are not entertaining this petition Article 32. He is at liberty to approach the High Court.
Your Lordship, I am parting person. Page number 158, Your Lordship. Earlier I have filed the writ petition, Your Lordship.
In 45.
158, Your Lordship. 158.
Yes.
So this is a writ petition I filed against the same order, Your Lordship.
Yes.
And which was dismissed on the ground of maintainability, Your Lordship.
Yes.
So now I filed a special leave petition, Your Lordship.
Yes.
Challenging the CAT order, Your Lordship.
Yes.
Your Lordship, why I have not gone to High Court means, Your Lordship, writ petition under Article 226 and 227 is not a appeal, Your Lordship. So I need a substantial appeal, Your Lordship.
Are you BJP appeal here?
Your Lordship?
BJP appeal here.
Yes, Your Lordship. As a special leave, Your Lordship.
The special leave is not an appeal until the leave is granted.
After special leave is granted, it will be converted as a civil appeal, Your Lordship.
Compared with the provision and language of 136 as well as 226. Have you compared with the scope of 226 is larger or 136 is larger?
So 136 is larger as well as 226 is larger, Your Lordship.
In a cases where the orders have been passed by the tribunal, no scope larger than 226, 227. Unlike 136 scope is only of leave. There you can go and address the court on the points. Here until we grant the leave, you have no scope.
That's true, Your Lordship.
So go before High Court.
Your Lordship, kindly make a direction to that effect, Your Lordship.
We are not issuing any direction. You have a remedy available, you take a recourse as permissible under the law. Not before us.
Your Lordship,
136 at present.
Your Lordship, I will have to fight out with delay, Your Lordship. So kindly pass an order saying that.
No, we can't say anything. We are not saying you are taking a recourse even before this court with a delay of 291 days. Why we should condone once you have made a delay here?
Your Lordship, there is no delay, Your Lordship.
High Court may look into.
Your Lordship, I have clearly explained delay is not
No, they are
really.
not entertaining this SLP. Speaking. Arising out of an order of the center, mistake with terminal dated 4/12/24. The petitioner is directly opposed to this court. However, he is at liberty to take recourse as permissible. There is a delay of 291 days also in filing of the SLP. Considering all the aspects, we are not entertaining the SLP.
Lordship, I have a remedy of administrative review, Your Lordship. So I can have
Whatever
it.
you want to do, you can go for it. Order of the CAT and the order of review. Dated 7th of August 2023.
My Lord, 61 is a complaint case, my lord, where cognizance was only taken under 498A and 323 IPC, my lords. 498A is up to 3 years, so for until and Ernest Kumar, I should be granted the benefit of anticipatory bail. I have no antecedent, my lord, but High Court has read the entire complaint as if 307 is made out against me and dismissed my anticipatory bail application, my lord.
What antecedent you want to do in this case? You want to go for a second marriage, then you will do
My lord,
rearrangement, then
we are paying maintenance also.
You want to do this?
We are
Antecedent, you want this?
no, my lord.
Then
Just making out a case for anticipatory. We are paying maintenance, my lord, and we are willing to live with the wife. Page 35 mediation has been failed, my lord.
I appear for the state.
see, you appear for this state, just
It's a
therefore
fresh
you are
matter.
asking.
It's a fresh matter, Your Lordship, and it's a complaint case. There is no investigation, Your Lordship.
Issue notice. Within 4 weeks. At least 6 days. On behalf of the state, noticing accepted. Hence paid. Restored. Notice to issue to be supplement the sub. Since it is a complaint case, the supplement be served.
She is respondent number 2.
Huh?
She is respondent number 2.
Complainant respond number 2. But please. In the meantime, no course instruction. This is subject to the court.
Grateful.
I'm grateful.
In this letter, Lordship, only single adjournment I have taken the whole 2 years trial.
You are taking, sir.
Lordship, may kindly see the page number. Is
Why
it-
taking adjournment, sir?
Lordship, only single adjournment. On dated
Now
4,
you appear now every day.
Lordship, every day appearing on,
Can we record your statement that now you will appear on every day?
no Lordship, I'll appear. Subject to exemption because I am 68 years old, medically challenged, so sometimes,
Sir, please, we are asking, would you appear regularly on?
please Lordship, please.
Okay. Let counsel for the petitioner. And stated that it is a case in which merely asking an adjournment for a single day, the cancellation of the anticipatory bill has been directed. It is stated by him that the petitioner shall regularly appear in the proceeding until leave is granted by the court, considering a proceed. Issue notice. Mr.
Notice on behalf of
The state.
is accepted.
Your Lordship, I am caveated for respond number 2.
1 and 2 is accepted. 2 may file. Let me dispose of, madam, why this is unnecessary.
Please, your Lord.
Keep it pending for no reason, madam.
Please, Your Lordship.
One day he not appear, ask for adjournment to pass an order of cancellation of the bail.
No, Your Lordship, the reason was different, Your Lordship. He had disclosed.
We don't know what is different reason.
No, Your Lordship, the reason.
For now he will appear on every day. What is required, madam? It will delay everything.
Actually, Your Lordship, I thought.
Rising out of it. हटा दीजिए पूरा कॉपी. Notice is accepted by the respond number 1 and 2. LNF counsel appearing on behalf of so and so. Police provided consent of the party to begin case.
Your Lordships, if I am permitted to reply, Your Lordships, to my knowledge, I have not gone through the SLP because I just filed my. I am sorry, Your Lordships.
If you notice, at this stage, so and so accept notice. दोनों की तरफ से लिख लेंगे. You may file counter affidavit. In the meantime, operation of the order passed by the High Court shall remain stayed, subject to appearance of the petitioner regularly during the.
That's grateful.
Grateful.
The petitioner, the case for anticipatory bail. I am the owner of the vehicle and I had leased out the vehicle to these people. And that was used. And I would not shy away from pointing out that during the course of investigation, they say that.
Only one question to you.
Yes, Pala.
And then you decide.
Yes, Pala.
Page 38, paragraph 7 of the lease agreement. You are aware of everything, eh?
No, that's.
You are aware that this incident may happen. So therefore, if that would be done, you will not be responsible.
No, that's one important. No, I understand what is falling from my lord. The problem is, in Gujarat, if you lease out the vehicles.
Can you understand, sir?
I understand.
This can be written.
I understand. I understand, but but it's only liquor. It's not something greatly in some narco substance. No, kindly consider only. It's a 6 months and 9 months imprisonment offence.
Whatever it is, sir. This is not a case. On filing of this document, even otherwise, is not a case. We can understand. You will say, sir, you have seen this also.
Yes, Pala.
Then you will point out.
No, Pala, I was about.
What is this? What is this? Paragraph 7.
No, paragraph 7. I'll try and explain then, my lord. I'll just try and explain. Palace, the problem is.
He can understand, sir, everything.
No, generally the leased vehicles are used for all these things. That's why there was a precautionary.
You are also counsel, sir.
Yes.
Since last more than 35 years. Don't say this.
Grateful.
Huh? We understand everything.
Yes, Palace.
With all equities, we are in favor of everyone. But if you go and making out a jalebi and MRT to us, sorry.
No, my lord. Not even an attempt, Palace. Not even an attempt, Palace. But kindly just consider two aspects.
No reason to interfere.
Palace,
nothing doing.
Obliged. Grateful.
Yes, my lords. My lords, the petition raises an interesting question of law. The communication involved is gratitude journal, which I have, wherein I pay gratitude for 5 good things that happen on the day. It will.
Notice, then we look at it. This is a point in the context of section
122, my lords.
The BNS section.
BNS, indeed.
Because it is perimeterial.
We
have seen that also. We
my
look
lords.
into that. It's a point to be determined.
To be looked into. My lords, would it be possible to consider stay also? Because this exhibited is marked.
It's a gratitude general.
Indeed, gratitude. So it's to self and to individual.
Very well. Gratitude general, what do you mean?
Very well. The word itself is self-explanatory. My lords may consider if stay, my lords, because this has been exhibited, marked, and my cross-examination if the trial continues based on this document. And what is the veracity? This was taken 2 years back when he left the house. Suddenly it's come. Now what's the veracity of what he can add and, change the tone of the entire complaint?
Still, you have to explain one thing more. You see the language.
Indeed, my lords.
Language of 122.
My lords.
Language of then there are evidence act then.
My lords. It's on page O of the SLP.
Yes, it is quoted.
Page O of the SLP, my lords. No person who is or has been married.
Yes, these
Shall
two words. Who is
or has been married.
You have to come prepared of this.
Very well, my lords. I'll get back on this.
To know this. Tell no good. In 6 weeks. In the meantime, the further proceeding in fact, give the court number and case.
Indeed, my lords.
Tell the main stay till next day. This one date fix kariye.
Be grateful, my lords.
Pursuant to the caste certificate issued by the competent officer, the SDO, I was appointed as a Ayurvedic medical officer, my lords. Now, my lords, I'm seeking no coercive action, my lords.
In the meantime, no coercive action.
Much obliged, accepting notice. Much obliged.
Except the counter be filed within a period of 6 weeks. Within the 2 weeks there.
Much obliged.
Date may be fixed after 8 weeks.
Much obliged.
Please, Lucy.
And for this, my counter is there in the second matter.
I'm for the petitioner, my lords, in both the matters. Whereas the matter was sent to the mediation, my lord, but the respondent did not appear there, my lords.
No, your lordship, we were appeared. I don't know why he is submitting this.
Apologize, my lord. I was informed that respondent did not appear before the.
Yes, 66.1. 138 matters, your lordship.
In another case.
Yes, your lordship. This is 138 matter only, your lordship. It's covered by your lordship's judgment.
For whom, madam?
And for the respondent, your lordship, in both matters.
Respondent means?
Respondent company, Anabont versus Anabont Limited.
Why you file the case there? In
Your lordship,
you have offices everywhere.
No, your lordship, our corporate office is at Chennai.
No, maybe at Chennai, but this where this check was issued.
Your lordship,
There.
Your lordship, we have manufacturing units in all over India, and our corporate office is at Chennai, and we are in a uniform basis. We are.
Office doesn't mean your offices are situated everywhere.
Your lordship, that's what we are saying. All the matters, our corporate office is at Chennai, and we have deposited the
corporate office. We have understand, madam.
Yes, your lordship.
Or corporate office doesn't mean that every litigation would come there. It's a matter, simple matter of negotiable instruments act. Which office dealt with?
Your lordship.
Whether corporate office dealt with this negotiable instrument act case? No.
Your lordship, it's
the office who take on the check would deal with.
Your lordship,
so why should not be
only our manufacturing unit is at Jabalpur, your lordship.
No, madam.
And both the matters and
like a harassment.
No, your lordship, can you see?
You can't permit the harassment in a court. At one occasion, court is going to the footstep of the person who is agreed. And the another way we do this thing. Which your office has been dealt with this issue of checks?
Our main office is at Chennai only, and our corporate office is at Chennai only. The Jabal.
Not asking. Your lordship. Main office.
Your lordship. In Jabal.
Asking which of your office has dealt with this loan transaction.
Your lordship, that's what I'm submitting, your lordship. The Jabalpur office only that manufacturing unit is there. We have manufacturing units all over India, and all the transactions we have.
Your office in Jabalpur or not?
We have only our manufacturing unit and an office which controls the manufacturing.
Leave it, sir, madam. The judgments are there, but we have to look into this aspect.
Tell your office, you kindly see the document with page number 90. If you look. Everything is on Jaipur. Then asking you to come in Chennai, we have find it. Your office then Jaipur can handle it. Like we transfer it.
Lordship, you should kindly see the judgment, Your Lordship. Your Lordship, Your Lordship, that. Your Lordship, all the cases we are controlling from a corporate office itself, Your Lordship, after this COVID. Otherwise, it will be difficult for us also. All over India, we have to file in.
To you people. Yes, 67.
67, you have respondents. You filed a counter saying that the charge sheet has been submitted, cognizance has been taken. And they're very close relatives and close relatives. And the old land dispute. And informant was not an eyewitness. And the last and the least point, Lordship, what I've said is the injury report, they show simple injuries, only grievous on the wrist. Similar as if they say that the informant says that it was hammered with sickle and rod.
You are for the complainant or you are for the state?
No, so I am appearing for the state minutes. Respondent number 1.
So I'm
I am appearing for the petitioner, my lord. I am appearing for the petitioner, my lord.
What is the nature of injury, learned state counsel?
Well, that's injury number 2. Your Lordship will see injury number 1 and 3 are grievous in nature. Injury number.
Can gather this.
Lordship will come to the injury report, which is annexed as an extra CA1 at page 7 of my counter affidavit. An extra CA1 at page 7 of the counter affidavit, Your Lordship may kindly see.
Yes, sir.
May I read, Lords? Injury number 1 is bleeding from left ear, CT scan of brain advice. Injury number 3, laceration of 5 centimeters, etc. Margin on scalp left hand side. Now on the opinion aspect, my lords. Injury number 1 and injury number 3 is grievous in nature as CT from Bain plus diagnosis reveals hemorrhage, SH, intrapharyngeal hemorrhage, contusion and hairline fracture of
brain CT scan done.
My lords.
Yes, brain CT scan done.
Yes, your lordship. Brain CT scan is done. He was been admitted for last 2 months. Still, he cannot stand on his own feet.
Madam, would you wait? Madam Sankita,
broken. That is.
Madam Sankita, we are audible or not?
Yes, your lordship, you are audible, my lord.
Yes, Mr. Government Counsel, there is that CT scan. Bleeding from left ear, CT scan of brain advised.
Lordship.
Is it done?
Lords, he was advised because this is the medical report by the doctor, Lords. He was advised done, but
done, sir.
CT was not done at the instance of the state, Lords.
My lord, if my lord may kindly see main petition page number 11, my lord, there is a CT scan is there, my lord. Page number 10 and page number 11 of the main petition, my lord.
Yes, please.
Page number 10 and page number 11 of the main petition, my lord. The whole pelvis, if my lord may permit, I may. My lord, even the statement of the victims has not been recorded till date, my lord. He has been admitted for last 2 months, my lord. And the CT scan and the injury report suggest that whole pelvis bone has been broken by rod, my lord. Both hand were fractures, both pelvis, he cannot stand.
Charge sheet has been submitted in the meantime. Cooperate with the investigation. Cognizance has been taken, and trial is, my lords, on the way.
Sir, but
Number
not
one.
a case
Number,
of participant.
number two, my lord, number two, my lord. We are all very close brothers. My lord, they are cousins. Lordship.
Attack on the.
No.
There is
Lordship,
open and,
No,
my lord,
they
there is open and direct.
We are asking the other side, just wait.
my lords, they are all Fufera brothers, my lords, because of land dispute. And in the FIR it has come that there's been an old land dispute, my lords. And number two, my lords, the injury weapon used was, my lords, it was saying sickle, rod and knife. But they are all hard and blunt substance. My lords should see in the injury report, page 7. And all the reports which she got was from private hospitals, my lords. Number one, my lords. Now I can compensate on that, my lords. She has given a bill of 1,50,000 rupees. But lords, you would see, they all, my lords, all the private documents, my lords, they are all private documents. The injury report of the government, my lords, would show that it's all by hard and blunt substance. Whereas in the FIR, it is, nobody saw assaulting, my lords. Informant is the Pardhanashil lady.
No, my lord, there are video recording,
not there.
evidences are there.
Says that I saw
And
my
my
husband
lord,
fallen.
there are
Everybody is around,
eyewitnesses
villagers
who
had
has to
come.
be examined.
Just-
We have already moved in application for that, my lord.
Either there is a mannerism, you have argued your case, you would wait, we are asking the other side, you are starting speaking, this is not good, man, please. Wait.
Because in the FIR they've said, the translated copy, the above mentioned people started attacking my husband with a knife, rod and sickle, my
Have
lords.
you received these documents?
Well, yes, my lords. Those are all private.
Have you filed any counter document to this?
Okay, can I file that? Because they are private documents, my lord. Those are private, lordship, I'm just submitting.
Does that mean that
No, what I'm,
every day the private hospitals also?
my lord, what I'm submitting, we also,
We can say the private hospital report is not correct.
my lord, what I'm,
The CT scan report of 12th June 25.
my lords. My lords.
Alright,
My lord.
June 25.
My lord.
Alright, it's a fracture over the head. It was advised by the government did not do it.
My lord.
Doesn't mean the person is admitted in the hospital and now this is a case. Certainly it is a dangerous to.
Well, what I'm submitting, my lord, lordship, charge sheet is submitted, my lord. There is no investigation, there is no chance of custodial interrogation, my lords. I'll appear in the trial, my lords. Bind us down, my lords. Bind us down, my lords. I'll appear in the trial. The cognizance has been taken. Let the trial carry on, my lords. We will not, my lords, even be around them. My lords, there's a property going on, property dispute going on. Repeated.
Property dispute, there are courts available.
Courts are available, my lord. And they are planning to, my lord, I think they have filed civil suit also.
Property dispute, courts are available, the courts are permitted, courts are given.
Yes,
civil courts, criminal courts.
That is also going on, my lord.
Permitted to
That is-
take the law in their hands.
The law in the hands in the sense, my lord, I have also suffered injuries. I did not, my lord, file FIR. They have filed FIR, my lord. Mischievous, we have suffered graver assault, but being a relative, we did not file, my lords. One of them has grievous injury, and one.
It has been filed.
Charge sheet has been filed and cognizance has been taken, my lords.
So now it is in the court, madam. Any custodial interrogation is not required. What do you want to say?
My lord, I just want to say the first on the injury part, my lord. Once in
Injury part is fine.
62-year-old person.
Injury part
Yes, my lord, there are high witnesses who need to be examined. There is an open threat to all the witnesses, my lord. They can't, the police has even not recorded the statement of the victim, my lord, who has been hospitalized for more than 2 months. I have been given open threat to leave the village, otherwise you, whole family, all female are there on one aged person. My son is studying outside.
I will go outside.
Outside you will not
In fact, I am outside now also.
There is a, my lord,
I am
statement
outside
of
now.
all the witness has to be recorded. There are eyewitnesses.
Doing some work, my lord.
Video recording,
I come only for the
photographs are there,
festival.
my lord.
Incidents to
A person, whole female, bone, the backbone
This is
bone has
Jharkhand,
been
small
broken,
village
but
in
the rod
Jharkhand, Milord.
is a major injury at the head. Both hands have been
Name of Jharkhand, district Pakur, Milords.
that has been operated,
Pakur.
and that I have
And Milords near to Bengal. And they are all working in Bengal, Milords.
Sangeeta, you want to say?
in fact,
Madam Sangeeta, you want to say anything else? Okay.
yes,
Please tell us what you want.
my lord, I just want to say that the statement of all the eyewitnesses has to be recorded. There are more than 8-9 eyewitnesses. Video recording has to be submitted. Statement of victim has to be recorded, my lord, and there is a complete apprehension of the threat of life even for myself, for my younger daughters, and the person and the victim, my lord. The statement of victim has not been recorded. How they are going to give their statement before the court, in the court, my lord? Just an anticipatory bail on the first day in such a grievous injury. That age-old person, 62-year-old person who has been attacked by the rod and whose lower part has been broken, both hands have been fractured, and they are out, my lord. How the statement are going, how the witnesses are going to the court without any fear to record their statement, my lord?
We will consider. Please consider. Who is for the government side?
The photographs of that.
Who is for the government side?
Milords, I appeal for the